Welcome to Kickbox Live. We sure appreciate you joining us. My name is Jack Wrigley, and I run partnerships here at the company. We are coming to you live, of course, from our worldwide headquarters in Dallas, Texas. I'd love to say we're on the 90th floor, but we're actually on the second floor, which of a very cool building nonetheless. Clearly, I'm joined here by Dennis Dayman of Return Path and Lance Stone, who works with us here at Kickbox. Before we get moving, just a little bit of stuff that we have to get out there. We're not attorneys, at least I'm not. I don't believe anybody here is an attorney. So please don't take anything we talk about today as legal advice. But it is good information as you work through the GDPR process. Hopefully you'll learn some things from today. And certainly if you have any questions after this, don't hesitate to reach out to us at help at kickbox.com, and we'll be sure to answer any of your questions. Without too much fanfare, Dennis Dayman is the Chief Privacy Officer of Return Path. He's got over 20 years of experience in fighting spam and things around that. He's on numerous boards and things of that nature with regard to the messaging industry. A very knowledgeable person, and we just really appreciate you being here, Dennis.
Thanks for having me.
Lance Stone, although I can't talk as long about you.
No,
Lance is our compliance analyst, and he has been very integral in our own personal GDPR efforts here at Kickbox. He loves GDPR. He eats it, breathes it, digests it, and he deals with it every day because we've been working on being compliant now for some time. So Lance and Dennis, really do appreciate you guys being here.
Yeah.
When we first set out to create this Kickbox Live, we had this kind of big grandiose idea that we were going to create this, multi kind of pronged sort of webinar aspect. And what ended up happening, fortunately, was that as you signed up to listen, you submitted a number of great questions. And rather than, kind of go through this process of, structure, we're going to just dive right in and start answering some questions from you folks, because the questions were excellent. And we think that the answers to those questions will be valuable for everybody. One other little piece of business before I get moving. I do want to state that these two gentlemen are going to be available next week. I know that you're both traveling. And Lance, you're going to be in San Francisco on Tuesday.
Yep.
Can you just provide a little bit of info about what you're doing and when you're doing it?
Yeah, it's a really fun event. So I'll be in San Francisco on Tuesday at an event called Hot Stacks, and it's basically an engineering gathering. We're going to be talking about GDPR in terms of the technology that you can deploy and ways to automate and stay compliant. Truly the best way to stay compliant is to automate, because then it takes, this, we were just talking about this earlier, right?
We geek out all the time like this. It's just,
So I get the fun job. I'm gonna be hanging out with a bunch of nerds and geeks and talking GDPR and tech stuff.
That's awesome. And if you want any information about that particular program, when it is, where it is, again, just shoot us an email and we'll get you that information. Dennis, I know you're going to be in New York City next week.
It'll be New York Hall next week.
Yeah, and that's for, I think, an EEC event.
Yeah, it's going to be for the Email Experience Council, which is the Email Experience Council, or Email Evolution, some people call it as well, in terms of the conferences. But we do these regular meetups in different cities. And so next Tuesday at the Sell-Through headquarters, they're going to be buying drinks. We're going to be in the World Trade Center building, actually. And we'll be hanging out there. So if you want to come, just go to the Email Experience Council's website, click on the events, register, and we'll be there on Tuesday.
That's awesome. And I encourage you guys, if you have an opportunity, get out and meet these two gents. Really smart, super cool guys. More than happy to talk at length about GDPR and anything else for that matter. So they're available, and I encourage you, if you have an opportunity, to get out and meet them. So why don't we just dive into some of these questions, because I think these questions were really, really awesome. And again, thank you so much for submitting them. If we do read your question, remember, we call it Winner, Winner, Chicken Dinner. You get a cool Kickbox t-shirt, and we'll make sure you do get that. But thanks so much for these questions because they're great. The first question.
What about the crazy stories?
Oh, yeah.
Oh, that's right. See, we're already off track.
Okay.
Okay, time out. So what I want to do is I want a couple crazy stories about GDPR before we get into the serious stuff. I know that this whole process of GDPR has been going on now for years, let's say. And you've heard some funny things, and maybe you could just share a couple little anecdotal stories or, experiences you've had around GDPR.
I can think of 20 easily.
Appropriate ones too. I've got some really bad ones too.
Exactly.
But, so I can tell you my favorite one for sure. This has been uncontested for the last 2 months because as we get closer to GDPR, it starts to heat up, and you get more and more support requests, and you get more and more partners that reach out to you and say, "Hey, what's going on?"
Right.
So this was about a month ago. we got a customer who chatted into our live chat system, and I handle all of the incoming GDPR inquiries. So it got fielded to me, and basically what they said is they said, "Hey, I'm empowered by GDPR. I'm an EU citizen, and I want you to delete all your data on me." And so I thought, oh, okay, awesome, a data deletion request. It's not even in effect yet, but let's practice, right? And so I said, hey, no problem. We totally take this very seriously around here. What data do we have on you? Let me know your account email. Let's pull this up. Let's figure this out. And he said, well, we don't have an account. So, yeah.
That's awesome.
Yeah.
Just covering all his bases.
Right.
Pretty much. He's ready to have it deleted before he's even signed up.
Yep. Yeah. Now, somebody asked him, he said, yep, handled Kickbox. Everything's good.
Right.
How about you, Dennis?
So somebody just recently tweeted that GDPR makes marketers really bad lawyers and lawyers really bad marketers. And that same thing exists, I think, for most consumers, because what we're getting now, same thing, is we're getting a ton of emails from people who are using these very harsh languages. And one of these ones that I printed out, and this is actually the really clean version of this, but at some point in this, it says, "You are not authorized to transmit any marketing-related emails of any kind to anyone on my behalf in perpetuity." And it's like, well, all of a sudden, like, okay, you've obviously been looking at a legal language or a dictionary of some sort here, but they all go out to these like crazy, just say, please, would you remove me from the list, or delete me?
Right.
And they have to go through this sorts of stuff. The second follow-up to this is we didn't have the email address either, and we had to go back and say, hey,
who are you?
Who are you? And they went, and they literally, it was a cursing, word sort of email, but it was like, you should know this. I don't.
Oh, but at least they had an account, right? Like, you still want to. Okay.
Exactly.
They literally just emailed privacy at, that was it.
Yeah.
So I have no clue.
So, yeah, absolutely. That's so funny.
Hey, well, at the end of the day, I know that we believe, and I think you guys believe as well, that GDPR ultimately is a good thing. Yeah. It's a very good thing for consumers. It's a good thing for businesses to follow. So, as crazy as those stories are, it's nice to see people are enacting on it and going for it, right?
Yeah, I mean, either way, they feel empowered.
Right.
So that's nice.
Well, that's the whole purpose of it, right?
Yeah.
I mean, really, when you start taking a look at it, it's not just about consent or anything else, but it's about giving the control and the security and the rights back to the end user.
Absolutely.
And you should take advantage of it as time moves on.
Definitely.
Yeah, that's awesome. So let's jump into some of these questions. Are we good to jump now?
Yeah.
Okay,
definitely.
Good. I haven't messed up the process. All right. So the first question is, do I need to re-permission everyone who opted in and pre-checked a checkbox? Does this need to happen before the law goes into effect? We've heard this question a lot, and I know you guys have some nice things to say about this.
Yeah, I mean, I think that's a really common question. People are, I mean, for lack of a better word, they're just freaking out, you know? And so figuring out, like, what do we need to do going forward is the important part, but people also are concerned about their historical data.
Sure.
So what we see is when we have customers or when we have partners and other companies that ask this question, we pretty much always just tell them, if you are compliant, if you have been compliant in the past, you have zero to worry about.
Right.
It's only if you're collecting the data in a way that is in violation of GDPR, then you have to worry.
Yeah.
So if you are already doing things the right way, if you've got a web sign up form, if you can prove that someone signed up, and then you're good, right?
Right. Yeah. And so it's funny that I think some people are kind of freaking out from the perspective of, we've had other regulations like Castle in Canada, which moved to a full-blown explicit opt-in. And now people had a very hard time back then, even though they had 2 years to re-permission. They saw the hits there, and like you said, they're freaking out about this.
Right.
But you're right that if you had already been following under existing regulations, EU directive, which was a little more softer on the opt-in, but in the email best practices industry, like from what we've learned and what we've been working with, that if you had gone to an explicit permission, you had documentation, opt-out, and that sort of stuff, like you said, you don't have to repaper this whole thing at all by any means. The problem is that, you know, even though we answer that to most marketers, they literally scratch their heads and go, well, I don't know. And you have to
That's the
kind of ask them, say, well, put some time and effort into this.
Do a little research.
Yeah, do some research.
You may well have that data.
Right. And that's part of GDPR prep anyway. You have to do an inventory of your data. You have to know where it came from. All of that is part of that.
Mm-hmm.
And Dennis, you approached me last week to provide a nice link to the ICO guidance on this very subject. So anyone who's interested in finding out some clarification, because GDPR can be a little hard to read sometimes.
Yeah.
That's an understatement, right?
Right?
And it can also be a little broad in language and scope. So it's really up to you know, each company to interpret and determine that. That's why your legal team is your best friend.
Right.
But yeah, so if you visit the ICO,
let's tweet that out off the
Kickbox
account.
Idea. Yeah, let everybody know where that is, because I think that was just an amazing clarification.
We'll tweet that out. That'd be good, because it's got really good examples.
Exactly.
Literally, it's like if Mary did this and Bobby did this, then this is what would happen, and it literally spells it out.
And that's what people want to see.
Yeah, we'll make sure we tweet that out from the Kickbox account, and probably tweet it out from yours as well.
Yeah,
perfect.
So that's awesome. So one of the thoughts here, I'm almost confident we're gonna have people watching this that are like, oh my gosh, I haven't even started yet, right? And so here we're talking. You know, GDPR goes into effect in about 2 weeks. We've all been knowing that now for about 2.5, 3 years, probably. You know?
Since 2012, actually, to be honest with you.
For quite a while. And we understand that there's some people taking this slow, but what about those people that are just like waking up now, going, holy crap, I got to do something?
You know. For the longest time, I think people thought it was going to be just a sort of like yes or no sort of situation, meaning that either I'm compliant or I'm not compliant with GDPR.
Right.
What we're hearing from most, if not all, the DPAs that are out there. I mean, I was just in London at the IPP event, and we had Elizabeth Denham, who is the ICO commissioner in the UK. We had the Irish Data Protection Commissioner, Helen Dixon, there as well. They all have said, you know, here's the deal, right? The world's not going to fall down. Like, you know, go off and do your jobs and whatnot, and get to some sort of place, because what we want to see is that at least you're working towards preparing, or at least giving the controls and the rights and whatnot to the consumers, right? As long as you're basically not just sort of, you know, giving the finger to everybody and saying, forget it, I'm just going to do it however I want. They're probably going to leave you alone. Let's also be honest. Like we were talking earlier today, that they got bigger fish to fry at this point. I don't want to name those companies, but there's been a little bit of scandal recently within the news, and they're probably going to be focusing on the majority of them anyways.
So, absolutely. And I mean, just in general, it's always to the discretion of the DPA whether to pursue or not to pursue. That's the truth of the matter. Bottom line. So they have the ultimate discretion on whether to leverage any fines, whether to conduct an investigation, and it's always up to them. So if you can prove and show and sort of demonstrate that you are trying to be compliant, that you've started somewhere, that you have good data collection practices, it's very unlikely. And of course, this is not legal advice, and not but I will say unofficially, off the record, and Dennis, I'm sure you'll echo this. It's very unlikely that a DPA would go up against an earnest company that was trying to, you know, solidify their procedures.
I mean,
so the important thing is just to start. Do your data inventory and start this process.
Well, and we saw that same thing in Castle, right? Castle came out, it scared everyone, big fines that were allowed. And those DPAs over there, in most cases, ended up doing very small fines, $10,000 to $25,000 fines for real basic, you know, email situations, not full-blown privacy issues, obviously. But they realized that there is a point where these companies will have to take some time to get there, and they're willing to do that. And we're hearing that somewhat unofficially from the DPAs,
but from the source, straight from the tap. So
well, and they're also at this point, the DPAs are strapped.
Yes,
you know, resource wise, right? We talked about this where, you know, some of them only have just, you know, 10, maybe 20 staff members, and that's everything. That's not just the investigations or the investigators that are there. So again, if they're going to be focusing any time and effort, again, it's going to be sort of on the ones where
egregious violations, huge problems, and or giant companies, right? Like that's just how that works.
So
yeah, for sure. So big message there. If you haven't started, start. Try to finish as quickly as possible. Keep track of what you're doing, and just keep moving forward.
Get a point person.
Get a point person.
Get a point person. Build out your GDPR team.
From our perspective, having you be that point person just completely help the situation out.
And then you have someone to blame if it all goes wrong.
Exactly.
Someone's got to go to jail.
Exactly.
That's awesome.
Dennis will be in New York sipping cocktails and having a great time. I'll be here answering for everything that goes wrong.
All right. No, that's awesome. So another question. Do we need to ask our double opted-in email subscribers if they want to stay, capital letters, opted in? So do you have to go back and ask someone who's double opted in to stay?
A double.
You know what I'm thinking,
Yeah,
a double.
yeah.
No, absolutely not. And that goes back to point one. So if you've collected it in an opt-in manner in the first place, and you have a record and you can show that in case you get audited by the DPA, why on earth would you need to go back and ask him to stay?
Yeah.
If the purpose hasn't changed, if you're not marketing, if you're not cross-marketing, so that's where that could involve reconsent or some sort of, if you have the permission to use this email address for a specific, very clear purpose that you have demonstrated and communicated, and as long as you're doing it for that purpose and they're aware of it, then that is considered permissive and you're good. If you then, if you're a yo-yo company and all of a sudden you want to start selling them sailboats, well, maybe then you might need to obtain that.
Yeah,
just depends.
permission, right?
Yeah, absolutely. But otherwise, no.
Yeah, so that's actually a really good point, though, from the privacy perspective. But the other thing is, the word double opt-in, it drives me insane these days. Now, and again, I've been doing email for
you and a few other people I know.
Yeah, it's just for
no names.
20 years.
We won't mention names.
But the double opt-in standard, there is not one. GDPR does not talk about having a double opt-in standard, or even
it's not even a requirement.
It's not a requirement.
Right.
Well, I mean, there's explicit consent, when it comes to
which
sensitive data
could
types.
potentially be used for.
But double opt-in, at least in my 25 years of experience, is okay. Someone comes to the website, they fill out the form, they check off a box and hit submit. Then an email comes in, and you have to take an action on that email. Okay, good to maybe test that the email address is working and whatnot, but why go through that process where if they forget to double opt in or click that second time, you're going to lose them. It'll be an attrition.
Right.
So if you're worried about bad email addresses and whatnot, then sure, do a confirmation. Kickbox promotion here. Use the API technologies they have here, there you go.
Oh my God.
It's
with the Vanna White candy.
But use the technology there on the website that will validate that it's a good email address, and then still send them the welcome email address. It's still single opt-in.
Right.
The idea around double opt-in actually came out of Germany. It wasn't even related to online technologies. It was more in a court case about offline use of information and, more importantly, sensitive data. And it somehow transitioned itself into
this email tool.
Yeah.
Right.
And I don't get that.
Yeah. Now, one thing, just because I'll be remiss if I don't mention it, is that you do have to prove it. So double opt-in, one reason why that's attractive to people is because it does prove it.
Yeah.
But there are other ways to prove it. Yeah. If you are capturing form sign up, including the IP address and what have you, you can prove that someone came and typed that email address in. Then there, just as long as you have a record, and you have to be able to tie it to the individual, the data subject, and know that the person who owns the address provided it.
Right.
So it can be a great way to do it, but it's not explicitly required.
Yeah. I had somebody, we had talked about whether or not, if you wanted to use double opt-in, could you have the sign up form capture the IP? Right. So they fill out the form, hit submit, and capture the IP, send them an email, and then capture the IP again whenever they click it again and go, yeah, there's a match. The only problem is what if I signed up here and then I just took off with my mobile? And then later on the mobile, I went and confirmed it. It wouldn't match up. So, but yeah, you're right. It's usually you want, the date, the time zone. Right. The date, the time zone, the IP address. And to be honest, over time, if you're using, I don't know, some sort of proper CRM or marketing automation solution, you could probably also make a case where, like my IP, even though it's a dynamic IP, I keep that IP for over a month on my house. You could probably start making an inference that every time that I visited that website or did something with you. Yeah, so you can make a record to say, 90% of the time it's coming from the same IP that the sign up was.
Just got to prove it somehow.
Yeah, that's really great information for sure. So another really, I thought this was a cool question. All right, because everybody talks about GDPR, and you get these people saying, well, it only affects people in Europe. Well, and we can get into that at some point. Maybe that might be a whole show in and of itself. But this is a great question. Interested in understanding implications of cross-border transfers, given some of our providers are based in Europe.
So do they mean transferring the data outside of Europe? That's what the company is based?
I think so.
That's what I'm thinking of, yeah.
Okay. Yeah. Well, Dennis, you actually added some clarification to this at an earlier point. So it's probably best to let you sort of give your take on it, and then I'll.
Sure, yeah. So, so the question basically is, in the EU, under the existing directive, it basically states that you cannot process data in a country that's not deemed adequate by the councils there.
And that's where the model clause.
That's where the model clause comes in,
because they provide that adequacy where it does not exist.
Right. Yeah. So they make a list of all these different countries: Canada, the Isle of Man, the 28 members, soon to be 27 with Brexit, that are allowed that data can be processed in. Shockingly, the U.S. is not a part of that. Right? We are a buy one get one free nation. My wife will give away her social security number for a buy one go or a BOGO offer on shoes at Payless. Okay,
she's not listening.
No. She's out shopping right now. Actually,
she's out giving her information away.
Exactly right. But you can, and with existing mechanisms, one's called Privacy Shield. So like Return Path, Kickbox, we're all Privacy Shield certified. That basically states, and I think you manage that for the company here, but it basically states that I will abide by the regulations that are in Europe, and I will hold this data in the most highest reverence and security and all the good stuff. The same idea is coming over here within GDPR, that you still have to have you have to be an adequate country or a mechanism like Privacy Shield. You had just mentioned model clauses, which is another way of doing it. There's other more expensive ways that are usually used for the Fortune 100 companies called binding corporate rules, and that cost $1 million or more to do. The interesting about GDPR, though, is it's going to take this a step further and say that, sure, it can be about country, but it can also be about an organization within that country that has certification, or a territory within that country. And one of the more interesting things that I know you and I have been sort of keeping an eye on is there's been some talk as to whether or not California, the state of California, can get adequacy ruling, and you could move data to California. How cool would that be for Microsoft and Google and Apple and the rest of the companies?
Absolutely. Or Seattle for Amazon.
So you have to go through this process. And if you are processing data that you've European data you've captured, and you want to process in the U.S., you've got to use one of these mechanisms.
And that's really when we talk about coming into GDPR compliance, that's what it is. It's getting into that adequacy. And if you can't get a ruling from the EC Commission or what have you, then you just have to have you have to have a DPA. You have to become and in Article 42, it talks about certification bodies that are forthcoming. But I mean, we're 15 days away from it coming into force, and we haven't seen that. So right now, there's not a formal certification, but there are ways, obviously, to informally certify. So there's no stamp or seal or anything that says I am GDPR compliant, but rather it's your adherence to the GDPR articles and principles, and you have to assert that through things like Privacy Shield framework. Great, that was already available, but there's nothing new, so it's up to you. It's up to you.
But you can probably see, like, I know that you guys deal with them, and sort of we trustee/trustarc, right?
Absolutely.
For years we've all had email privacy certifications. They've had a privacy certification or Privacy Shield certification. Where Privacy Shield's what, $200? Is that what it is now? I think. I know it's based on revenue or size of company now. Or wait, that's the
Privacy Shield is flat fee.
It's flat fee, but then there's another.
You're talking about DMA.
Yeah, that's right.
Talking about DMA.
Sorry, DMA.
Yeah. Sorry, DMA.
Oops. But you can be Privacy Shield certified. You can do that in-house. But I mean,
self-certified.
You self-certify, but what if I miss something, right? And I have. And so you can go to some of these companies like TrustArc and say, hey, certify the certifier, certify, the person here. And they'll sort of go through and check. Now,
they'll check all of your processes, everything.
And see if it could be.
They'll put you through basically what a DMA or a DPA style audit would be like. They simulate that process for you instead of being super scary. It's it's a lot easier to get through that, right?
Well, and then they represent you. If a data subject, which is how this is defined, wants to come after you, well, then fine, they can, and they can go file a complaint with TrustArc. TrustArc becomes the middle person between the two parties, and we'll figure it out.
So, is there any indication yet on if you are subjected, if you're going to be put to task? How do they notify you? Have they discussed that yet? Do you just get an email? Do you get a phone call?
I don't think it's
road flares. What happens?
It's mentioned that I forget what it is. Sufficient notification, some sort of vague language will be made to the DPO. So your notification is going to come in not to your privacy email or your compliance email. It's going to go straight to your DPO because the data protection officer is always the front person for that, and they're registered as such. So if if the authority needs to contact, they're going to go to your DPO. So you'll know when your DPO tells you, and it could be, I suppose. Well, Dennis, you're the DPO. I'm not. So when you register, do you have to put your phone number as well, or just? I think they will ask for like a lot of details.
A lot of details, and a lot of contact information.
And DPO requirement yet, or is it a nice to have?
Oh, both.
Both.
Yeah. So just err on the side of caution, honestly. Like some companies that can prove that the processing of the data is limited and what have you, there's some very vague guidelines there. Right. Don't explicitly need a DPO.
And categories and stuff too.
Correct. Yeah. Like people who don't process certain categories of data. Some that are pseudo-anonymized and are never, some that are used for research, for furthering academic research and things of that nature. You don't necessarily have to protect that as long as it's not tied to a specific individual. But I think most people who are doing any type of commerce, offering products and services, let's be honest, you probably would need a DPO for that, right?
Like, and you don't have to have it in-house either. You can outsource this, right?
Yeah.
There are tons of law firms out there. I mean, you can usually go to any one of these and say, hey, I'll pay you X amount if you would just be that one contact person. And then their one job, because the DPO's job is to only educate and to keep up with the regulatory efforts and whatnot, but they end up doing it for you.
Yeah, which is really handy for smaller businesses and people that don't fuss with it.
But now's the time to become a DPO because it's really hard to get fired right now if you if you take the job, because they really can't fire you for
goals.
Exactly.
After the 25th. Look out. Heads on the chocolate.
Well, there's 75,000 open positions right now. They literally, at the IPP in DC and in London recently, they have a shortage, 75,000 open jobs right now.
That's amazing.
All right, I'm going to apply.
There you go.
See you guys later.
Created its own industry, hasn't it? That's good. So another question: is legitimate interest ever legitimate for direct marketing, either for prospect or current customer?
Who asked this question?
I don't have a name, but they're getting a T-shirt.
All right,
a T-shirt.
Do me a favor. No, right now. Whoever asked this question, hopefully you're watching. I want you to send me an email to lance@kickbox.com because I want to talk to you. That's excellent. I absolutely love that. Oh man.
So you want to answer it now?
Yeah, absolutely. So, yeah.
Well, so there's been confusion around legitimate interest, because
I didn't want to go too harsh, so I'm gonna let you do it, and then I'll fill it.
He'll soften it.
Yeah.
So there's been this confusion around GDPR that there is an idea in there that says, legitimate interest.
Article 6, lawfulness of processing. Yeah.
The problem with it, though, is it's for processing, not for sending an email, not for texting, not for communicating. Not for communicating. Right. And so it also gets a little more confusing because not only are you dealing with GDPR, but you're dealing with existing other regulations like e-privacy directive that's already out there, which has an opt-in aspect to it, more soft than anything else at this point when it comes to email and texting and phone calls. And again, that's being upgraded over the next, hopefully, another 2 more years, I think. But that's going to go from e-privacy directive to regulation, and that'll be complementary to GDPR. Then you have, for an example, within the UK, you've got the Privacy Electronic Communications Regulations, PECR, which has some prohibitions, again, where you have to have opt-in to do email. So you can't just look at GDPR and go, okay, well, it says this. You kind of have to apply other regulations that can. And I can't remember the word, but there was a legal word, and one of the attorneys that I've worked with occasionally had just recently said it, but basically the premise had been whichever one of the regulations has the most detail is what ends up being what you have to go after or use. And I think in the case we had talked about was GDPR was there and you had PECR there. PECR would be the one that you have to kind of go by.
Lowest common denominator.
Something like that.
I think they say that.
It was it was some sort of. I have to go look it up.
If it violates one, it doesn't matter if it violates the other. Like all you need is one, right? So you have to comply with the lowest common denominator, whatever will be in standard. And the reason why I like this question is because I think this is really what all marketers are thinking. I love that somebody fielded this question because it's important for us to answer it. Everyone is thinking, all right, so what is this legitimate interest thing? Can I use this in place of the other lawfulness of processing procedures?
And there's many of them.
And there are plenty of them, And so what we typically talk about with GDPR is just those two. We only talk about the legitimate interest of continuing the contact. But the whole idea of legitimate interest is it's very nuanced and it's very individual. It's got to be your specific company. So if you've done business with the person, you have a relationship with them, they've bought products from you, then you're allowed. This goes back to the yo-yo and sailboats example. Legitimate interest would cover me sending my current yo-yo customers a notification about my yo-yos, new products, services, especially if they've explicitly opted in. But even if not, if they've given the email and I've notified them that you may from time to time receive emails about Lance's yo-yos, then that is perfectly permissive and consistent with GDPR. But I can't market sailboats to them. They haven't opted in, and I haven't told them you may receive emails about yo-yos, but also sailboats. It's
Right.
got to be pertinent
Right.
and very clear about what they've opted into.
Right. So what Lance is just talking about here is proportionality, right?
Yeah,
And,
proportionality.
and expectations, right? It's when the client signed up for something, the expectation was yo-yos.
Right.
And at the same time, you have to look at the privacy impact to the individual if you were going to sign them up for something different.
Right.
Whose favor is that? Is it theirs or is it the brand?
Right.
If it's in your favor, then you probably don't have a right to use legitimate interest. Now, the other thing too that you have to consider, and this has been a fun debate recently. I don't know why we just started talking about this, but sure, you have the consent option, which is one of the lawful bases.
The easiest one.
Well, it's the easiest, but it's also the one where you can actually hurt yourself the most. Because by saying that I'm going to get consent from the individual, you have now put all power into their hands to say, I want to object, I want to delete, I want you to forget me now.
Modify.
And if it's in their hands and they tell you they want X, Y, and Z done, you got to do it.
Absolutely.
If you use one of the other 6 lawful bases, whether it's contractual, safety, all that sort of stuff,
regulatory,
you have a little bit more leeway. And I'm not saying not to go off and just say legitimate interest is on your side for everything, but you have to consider that.
Yeah, absolutely.
So.
Again, but it comes back down to everything else. You have to be able to prove it. So as long as you can prove that you have proportionality, that it's balanced, that the need to engage in that type of contact is reasonable for what the person is aware of.
Right.
So,
you know what we should tweet out as well is the legitimate interest assessment test too as well.
Oh my gosh, yes.
From the ICO's
yes,
office.
absolutely.
So the ICO released this document. It's really nice. At the very end of it, there's this little test that you can basically go through each one of these scenarios, and you can determine whether it's in your interest or their interest.
Right.
So yeah, we should tweet
Yeah,
that
that's
out.
great.
That's awesome. So in essence, then legitimate interest can be used for direct marketing sometimes, but it's not
if the relationship demands it, and you can prove it. Yeah.
But you got to always stick to purpose, necessity, balance, things of that nature. Right?
Exactly. Okay. Yes, absolutely.
Yeah, that's good information. All right, how we doing?
Great.
Good.
Good.
The producer seems happy.
Everybody. Hopefully, everybody.
She's not doing this or anything.
I just wish we had more time. We could talk. Dennis and I could talk about this stuff all day long.
We
do.
We're going to do this at the brewery next door, but
Right.
Well, this goes for 8 hours.
Awesome.
Okay.
Great.
Yeah. All right. Let's see if we can bang out a couple more questions here. Looking for some guidance on if or what we need to mention in our privacy policy about all the plugins, Facebook pixels, JavaScript codes from ESPs, etc., that we might be using. I love this question.
I do too, and I think your technology team will love this question.
Yeah,
because they get to give you all the details. And honestly, I really feel like, and Dennis, what did you over at Return Path do? Did you follow a similar process in terms of getting your engineers and your GDPR people together, having the engineers say, okay, this is what it does? Because the compliance people may not know what it does, and the engineers don't know what they need to be compliant with. So you got to kind of get them into the same room and table all that, right? And so that, to me, needs to be the beginning of your process.
Yeah.
Before you can put that on a privacy policy, you have to make sure that you understand it.
Yeah.
And then be able to describe it. Right?
Yeah. So so I think what a lot of companies have done, and I think what you guys are also doing here, is the idea of a privacy council, right?
Absolutely.
The council isn't just some CPO. It's not the privacy person. It's not the lawyers. I mean, it does include them, right?
Right.
But it includes people from marketing, people from sales, every department,
engineering,
And
management.
you meet together, once a month, once a quarter, whatever you decide. And you get to talk about what impacts are coming. Production can say, hey, by the way, like for Return Path, right, we made some changes to our backends, and they needed to sort of explain to us where they were going to be moving that data. And we need to go, okay, what's that impact under GDPR?
Right. And you're required to conduct privacy impact assessments periodically.
Basis,
Absolutely. Right. And especially in the event of a change to the data location, storage, the way it's stored, any of that stuff. So to describe that on your privacy policy then becomes an incredibly easy affair once you've done the legwork, right? You need to tell people how you're collecting the data, what you're doing with it, for what purpose, and GDPR requires it to be explicit in clear language. That's the most important part. No legalese if you can help it. Of course, you have to have some, right?
You have to have a little bit.
But you try to make it as easy to digest and read as possible. It needs to be unbundled.
Well, it's not the privacy policy isn't a contract. Right. It is literally
just a notification.
Right. Your contract would be your terms of service. And
that's where you get crazy with the legal language.
And go nuts with that one.
Right.
So, but the privacy policy piece, like like you said, you need to explain to them who you are, what you're collecting,
Right.
who you're sharing it with, right?
That's important. Yeah, I missed that.
And if you look, and if you look at it, right, I'll use Google Analytics as an example. They have in their terms of service that if you're using their product, you have to mention them very specifically that you are using them,
Right.
and link to their opt-out processes as well. The same thing would be for cookie tracking, right? We've got first and third party cookies that we've got that we have either with on our website or other companies,
Right.
and we have an ability for them to opt out.
That's good.
And it doesn't have to be anything crazy.
And the approach that we took with specifically with our tracking technologies and the we call that automatically collected data. That's stuff where people don't necessarily give it to a sales agent or interact with us. That's stuff like if you go to our website,
Right.
a lot of that, in fact, all of it really is to inform our automated processes that allow us to provide the service. In order to do like anti-fraud and to look for behavior that could damage the platform or violate our policies, we use automated systems to capture your IP address and as you move about the site and what have you. And they're all very clearly defined in the privacy policy.
And you wouldn't be asking consent for that because that's a legitimate interest on your part.
Correct. It's legitimate interest and it's regulatory. So you're exempted from having to obtain consent if it is in the service of regulatory stuff like anti-fraud and abuse prevention.
Yep.
So do you guys hang out a lot together?
We do all the time.
Yeah,
It's like,
we're always on Slack.
I'm just glad there isn't like a beer in front of you. This would be crazy. No, this is
He actually read all 99 articles and 173 recitals.
Yeah.
Every single one.
and he told us all about it.
Yeah.
So it's all good. Hey, there's actually a kind of a live question that I want to cover here. If you guys are
Go for you.
Great.
It says, what happens if we work as an email intermediary where party A enters an email for party B and our company sends an email to party B on behalf of party A?
Party B never opted in.
But party B never opted in.
Yeah.
So they're sending on behalf of someone,
Right.
but the person they're sending to on behalf of A never opted in. So
so you can't give permission for an address you do not own.
Yeah.
So we see the same thing with referrals where someone will refer someone to you and they want to give, what's that joke? Do you have a data protection officer? Yes. Can I have his email? No. because only the person who owns it can truly give permission.
Data subject.
The data subject must give their own permission. You can never give it for someone else. So in this particular case, I would say,
but that's wouldn't be GDPR compliant, nor would it also pass CASL.
Right.
I mean, most regulations today are at that point. It's all about the control of the data subject.
Yes, the individual who owns the address.
Yeah,
exactly.
That's really good. And that might be another Kickbox Live we talk about at some point.
Well, now what you could do is you could say, hey, company A, if for some reason company B wants you to send something on their behalf, then you know what, you're probably okay at some point to say, hey, you know what, by the way, every quarter you should be reminding your clients, hey, here's the emails that you signed up for. By the way, we also have a partner section in there. Feel free to sign up for one of those as well. And it'll go off to partner B at that point. You can do that, but you can't make that choice.
You can't just arbitrarily say, hey, right? Okay, good.
And anyone who's doing those intermediary ones, like the big ESPs and what have you, they'll have contractual agreements that protect them from liability. They may choose to do that.
And
if they do, exactly. Pretty much.
So here's another live question. We're gonna deviate, and then we're gonna try to hit one more of these, and then we're gonna be wrapping up. All right?
Okay.
I think this is a really, really great question. So if you have multiple brands under an umbrella, do you have to obtain consent for all brands? As an example, the customer purchases all brands and opts in.
Right.
I mean, how do you handle multiple brands maybe from one company?
I'm trying to think.
Especially if a customer is.
You know what I'm thinking of? I'm thinking of like just. And I'm sorry for calling them out, but like Pottery Barn, right? They have Pottery Barn Kids and Pottery Barn Teen, and
all of that stuff.
So I would almost say that right now, like if you basically are buying, as an adult, I'm not going into Pottery Barn Teens anytime soon for myself here, but
really,
but I would be the adult side of it, if you will. Abercrombie, okay. But I would only be allowed to get emails from the adult side, I would say at this point. I did not ask for the children's side of it. I didn't ask for the for I don't know what other brands they might have. It would be almost a separate opt-in, I think, from that perspective. Now,
can you send an email from the parent and say which ones do you want?
Well, that's the question, right?
Some of them do. I've seen that. They have checkmark boxes that have specific mailing lists that you can opt into or out of.
Would you say it's still a category of clothing and say that Pottery Barn sending out clothing for adults and for teens, and it's all the same information. It's just a different version of it. I would almost say that that's completely fine.
right,
from a regulatory perspective.
Yeah.
However,
if
it was clothing, and yet I was getting, I don't know, kitchen stuff from
yo-yos and sailboats.
Yeah, then we have a difference at that point.
Yeah, legitimate interest would not cover that, and your consent has to be given for a specific purpose, right? Like you say, I'm opting in to receive transactional emails from you. Those are required by the platform in most cases, right? You change your billing address, you update your email, like we have to send you something to let you know that. Marketing is separate, so that's always, you don't have to, and you can't bundle it. As a matter of fact, you can't make it a requirement for service, so that would violate that too. But yeah, I would say you would want to keep it separate. Emails that come from the parent company,
just because it's you just never know.
Best practice.
Yeah, you're just never going to go where the other side's going to end up changing.
Exactly.
The purpose could change at some point.
Purpose could change, and if the purpose changes, then your basis for processing changes, and you got to stop.
Right.
Yeah.
All right. I like this question as well. What if you're an EU citizen living in the United States? How does GDPR apply to?
Why are you here in the States in the first place? Have you seen our, have you seen our government lately?
That's so good.
Sorry.
Hey. Come on.
Our EU viewers, do we know where everyone's from?
Worldwide.
Worldwide. Okay.
Just worldwide.
So our EU viewers probably got a really big kick out of that right now. Because they're thinking, yeah, you're right, we wouldn't. Oh man, that's awesome. So this question has garnered a lot of attention, I think. Dennis has been a great resource for this for us because, to be perfectly frank, I was kind of confused about this at first too, and I think a lot of people are. Dennis, you mentioned that the laws of the land preside, and you gave a really good example. So I'll just kind of let you tell the story, but it's a good example, I think.
It's about my teenagers drinking. No, so the boys being 17 right now, my twins. We're going to be in Munich for MOG here pretty soon. And in Munich, Germany, you can drink at 16.
Right.
So if we go there, they're allowed to have a pint of beer.
Right.
I don't know if I'm going to do that, but they're allowed to have that pint of beer.
Yeah.
But when they come back to the States, 21's the age here. So the law of the land basically applies, and the same thing happens here. And we're still waiting, I think, for more clarifications on this. But if you're living in the EU, even whether you're a resident, a citizen, or even just Jack Wrigley going to the EU and living there for 6 months, the law of the land would apply. So if he was to sign up for some email system there while he's in Europe, then guess what? GDPR does apply, and he has the ability to use that.
Right.
But coming here, you don't.
Right.
You would only have canned spam and whatever else that you would have for you.
Yeah, so the best practice now, until we receive further clarification, because again, this is a little ambiguous in the GDPR articles themselves.
Yeah.
There's been a lot of speculation about it. I say best practice is to just govern based on the law of the land.
And capture where they're at.
Exactly. And a lot of, I think this question really comes from a larger question, which is, can we not have certain things in place for our United States customers, and do we need a special program for our EU customers based on where they are or which division or what have you? The best practice is just to do it for everybody, regardless. Yeah. I mean, ultimately,
that's what you guys are doing at Kickbox.
Yeah, we are. We don't make a distinction between it would be way too hard to track that, right? Like if an EU citizen came to Dallas, how would we know if they signed up on the website that they were an EU citizen or not?
Right.
And if we didn't protect it in the same way, we would be in a huge liability just by making a guess as, they must be from the United States because the IP address is from Ohio.
Right.
Yeah, but that guy could be visiting from Denmark or anywhere. It could be on a VPN. Exactly.
Right.
So because it's too hard to really get to that, the best practice is just to do it for everybody.
Well, and the beauty part about that is most of the countries, and we'll use Asia Pac as an example, they tend to follow the regulations of the EU because they're really good. And they change them. The directive was 95?
Yeah, 95. Then 2010, the new decision.
So they're continually updating it. So they're following that.
That's good.
So if you're a worldwide business like you guys are, and like Return Path is, if you follow the rules at this level, you're probably going to get everything else in there.
Yeah, that's great advice. So we only have a couple more minutes. And before we sign off, first of all, thanks so much for participating. I got to believe this is helpful for people. Any just final thoughts in terms of GDPR, where we're at right now, 2 weeks out? Can you give me something succinct in 30 seconds or less?
Yep. We're excited. We're
Excellent.
ready. We're ready. I would say, if you are just starting, like Dennis said earlier, just start. Reach out to the resources that you have available and don't overcomplicate it.
Yeah, that's I would agree. In fact, when we tweet out the resources for the ICL office, go sign up for their newsletters and their information.
Great information.
The UK ICO seems to be doing a really good job of leading that. Yep. And like Lance said, don't be afraid of it. Just go into it.
That's awesome. Just as a recap, you can see this guy next Tuesday in New York City. at the EEC event. Massively approachable. Go up and introduce yourself. Dennis is a great resource. Lance, same deal. You can meet him in San Francisco next Tuesday, doing a little brunch.
Yep.
Hanging out with the nerds, as you say.
Eating pancakes, talking to
Is this a Waffle House?
Eating.
No.
Okay. Just wanted to see.
That's awesome. At a Waffle House. Lance will be there. No. But Lance also very approachable and, as you can tell, very knowledgeable. Any other questions you guys have, please shoot us an email at help@kickbox.com. We will do our best to answer those for you.
We're going to do a blog on it.
Yeah. Well, we're going to do a follow-up blog to this, so be looking for that.
Perfect.
And I think that's about it. So thank you again for joining us. And until next time, have a great afternoon, everybody.